This is my first time on the Lunchtime Learning Bill. I'm Fiona. I'm the Senior Research Analyst here at calQrisk, and my first introduction to risk management was through a financial services lens. But over my years at calQrisk, I've developed a more holistic approach to the discipline. And those of you who know me will know that I do have a favourite branch. And if I were ever to appear on Mastermind, my specialist subject would probably include the GDPR, and I hang my head. Don't worry about notes today. We'll be sending out the slides afterwards, and you'll be able to access the video on our YouTube channel, and that's where you'll find all of the past Lunchtime Learning episodes, as well as many of our longer webinars covering a wide range of GRC topics. The presentation will be about 12 minutes, and I'll open the floor afterwards for any questions. And on that note, could I ask you please to use the Q&A function rather than the chat, because I could well miss them if they were in the chat. So while we're still getting settled, and for those of you who haven't been with us before, a little bit about who we are. We're a team of experienced risk and compliance professionals, and we comprise members of the Institute of Risk Management and other professional organisations listed there on the slide for you. Some of us have been and are involved in the development of standards such as the ISO 31000 Risk Management Standard and the ISO 27001. We design, develop and deliver an award-winning governance, risk and compliance software called calQrisk. And in Q1 this year, we also launched the risk services arm of our business, which offers risk management related training, advisory and consulting. We supply to regulated firms in sectors such as financial services and not-for-profit. calQrisk is deployed in the public sector and it's used by independent auditors. And we also have a presence in the education sector, among others. So I hope that gives you a little idea of who we are and the nature of our work and the scope and scalability of our products. And we'll move on now to what today is all about, and that's legitimate interest assessments. So in the interest of time, you'll notice we don't have an overview slide, but this one doubles up well because, as well as illustrating the 3 cumulative conditions of legitimate interest, it also sets out the 3 main components of a legitimate interest assessment. You might be wondering why I'm referring to the Court of Justice ruling up front, but that's because in the course of its consideration on 2 questions on legitimate interest in this case, which was referred by the Latvian Supreme Court, the Court of Justice set out in a very clear way the 3 conditions of legitimate interest provision in what was effectively a legitimate interest assessment, and those are purpose, necessity, and balance. The Article 29 Working Party predecessor, the predecessor to the European Data Protection Board, they issued a very comprehensive guidance on legitimate interest processing in 2014, and it features an introduction to balancing tests. And you'll notice that both of these situations predate GDPR, but since the article we were speaking about, which was 7F in the directive, became 6.1F in the regulation, they're still important reference points today. And over the next few slides, we'll walk through a legitimate interest assessment process, including some preliminary steps. And this is one of them. So here we are. We want to start a new data processing activity. Our first port of call generally when discussing the legality of any data processing is Article 5. And today is no different. Before we get to the whys and wherefores of our legitimate interest assessment, we first need to review our proposed activity against the GDPR principles. If it doesn't pass this preliminary test, we won't actually have to conduct an LIA at all because our plan will be dead in the water. So here in this slide are some of the things we should be foremost in our minds during the early planning stages of a new DPIA, or sorry, a new data processing activity. And before we do the LIA, before we test to see if a DPIA is required, and ideally before we engage a processor. And here they are. So the question, can the purpose of the processing be clearly expressed? Is the purpose lawful? Can the proposed processing be established as lawful? Is the processing fair? Are we transparent about the processing? Can we stand over our decisions and rationale? And can we evidence them? Okay, so let's say we have a purpose in mind. We now have to justify the processing in law because unless we do that, and I'm sorry for stating the obvious here, our processing is not lawful and we should not take it any further. So here we are. In order to establish that the processing is lawful, we need to determine now which of the available 6 legal bases we can rely on. Again, let's assume that we've settled on our reason for processing and that in considering the legal bases, 6.1a, which is consent, and 6.1b to 6.1e, which allow for processing subject to safeguards in situations where it's appropriate and necessary to process the data within a certain context in pursuit of a very particularly legitimate interest. We're assuming here that for one reason or another, they're not appropriate for our purpose. So that brings us to Article 6.1F, and that refers to any legitimate interest of a controller or indeed a third party in any context. So now we'll go on and determine if we can rely on this ground as our lawful basis for processing. And here it is, Article 6.1F again, and I've underlined the key features to identify those 3 cumulative conditions of legitimate interest laid out by the CGEAU, and that is that the processing is necessary, that it's for the purpose of pursuing a legitimate interest, and that it cannot be relied on if that interest overrides the interests, rights, and freedoms of the data subjects, particularly where the processing involves the personal data of children. And it's these conditions that form the basis of a legitimate interest assessment, which we should be conducting anytime we want to rely on legitimate interest as grounds for processing. So what kind of purposes might be permitted under legitimate interest? Well, the GDPR recitals is where we'll go for them, and they suggest a number, and you can read them here and get them in more detail in the recitals. But for example, if you're planning on processing personal data to an extent that is strictly necessary for the purposes of network and information security, these are specifically identified as legitimate interests in Recital 49. If your organization is a company or an institution that is part of a group or affiliated to a central body, you may have a legitimate interest in processing personal data within that group, subject to appropriate safeguards. And that's in Recital 48. Recital 50 tells us that processing to indicate possible criminal acts or threats to public security should be regarded as legitimate interest, but only if the processing is compatible with the legal, professional, or some other binding obligation of secrecy. And in Recital 47, we're told that the processing of personal data that is strictly necessary for the prevention of fraud amounts to legitimate interest. We're also told that it could exist where there's a relevant and appropriate relationship between the data subject and the controller, so such as customers and employees. And it indicates that processing for the purpose of direct marketing may be regarded as a legitimate interest. And while these circumstances appear in the recitals, GDPR articles are silent on what should be taken into account when deciding if your purpose is legitimate interest. So what we can take from that is that legitimate interest is broad, meaning that if your interests don't have, they don't have to be very significant. They may even be of little importance. So it could be as simple as your legitimate interest to begin a new business activity, or indeed to grow your business. And something to bear in mind is that just because an interest could be considered trivial or even controversial, it doesn't make it any less legitimate for the intended purposes, but it could well mean that these interests are more easily overridden in the balancing test, or if the individual objects under Article 21, and then you no longer have an overriding interest, and so you must stop processing. So the purpose test is the first key element of the LIA, and there's some great guidance out there around LIAs, and a good place to start is with our, your National Data Protection Authority. So the DPC here in Ireland does refer to it in its legal basis guidance. The ICO's guidance is particularly a good one, and I would recommend going to their websites and having a look while they're still on par with us. The IAPP website also is another great source of guidance, and I'll link to any I've come across in a bibliography at the end of this slide deck, which we'll be sharing with you. So here on this slide is an example of the types of questions you might ask when testing the legitimacy of your interest. To demonstrate you have a valid interest in processing requires you or a third party to have a clear and a specific benefit or outcome in mind. So it's not enough for us to rely on vague or generic business interests here. What we need to think about is what we are specifically trying to achieve with this particular processing activity. So for example, we might say we have a legitimate interest in processing customer data, but that doesn't go far enough because it doesn't clarify our purpose. So we may be using a statement such as, we have a legitimate interest in marketing our products and services to our existing customers in order to increase our sales. Worth remembering here is that while any purpose could potentially be relevant, the purpose must also be legitimate. So anything illegitimate, unethical, or unlawful is not a legitimate interest. So again, going back to our marketing example, while marketing may in general be legitimate, sending spam emails in breach of e-privacy rules isn't. So that's the first step of the LIA. And if at this stage the interest is not legitimate, then we fail to satisfy the first part of the LIA, and we can't use legitimate interest as our lawful basis. So there's no need to consider the rest of the test because they're cumulative conditions, and satisfying the other parts won't legitimize the processing that fails at this step. So we next have to carefully consider whether or not the envisaged processing is actually necessary for the purpose we've identified. So the kind of questions we could ask here is, will the processing actually help us to achieve our purpose and the outcome that we want? Is the processing proportionate to our purpose, or is it excessive? The ICO actually asks, is it a sledgehammer to crack a nut? So that's, that's a great way of putting it. Can our purposes be achieved by processing less data, or indeed without processing any at all? And can our purposes be achieved by processing the data in another way that intrudes less on the data subject and or is more likely to be expected by them? So it's important to be open and honest with yourself when testing necessity. If you identify alternative ways that are less intrusive to and more likely to be expected by the data subjects, we should document those in our LIA along with our reasons why we haven't opted for them. And another good tip here from the ICO is that if at any point we find it difficult to explain how the processing helps to achieve our objective, or where we identify a number of alternative methods that don't fit our business model, that we go back and we restate our purpose to ensure that it's as specific as we can make it, and that will make, the necessity part of the LIA easier to get through. And finally, this is the balance test. So this is potentially the most complex part of the LIA. Here we need to balance our legitimate interest against the interests, rights, and freedoms of the data subjects involved. Now, all data processing carries an inherent risk. That's just a fact. So much like we would in a DPIA or indeed any risk assessment, we should consider the context of the processing, the nature of the personal data, the category of the data subjects involved, their reasonable expectations, the impacts, positive or negative, that the processing is likely to have on them, and what measures we can put in place to mitigate those potential negative impacts. So the type of questions we want to ask here are, what is the context of the processing? Is it one-off or is it long-term? What is the nature of the personal data being processed? Is it special category data prohibited under Article 9? Is it otherwise sensitive data, such as relating to an offence? Is it financial information, such as credit rating, or some other data that the data subject would consider private? Could the data subject reasonably expect this processing? Do you have a pre-existing relationship with them? Have you used this data in the past? Did you get the data from a third party? And if so, was the data subject informed about the possible reuse? Have you consulted with the data subject population? Have you done surveys, focus groups, etc.? So what is the likely impact of the processing on the rights and freedoms of data subjects? So here we identify the potential risks to and/or opportunities for the individuals involved. And we do need to pay particular attention to this, because if the likelihood of a negative impact is high, we will have to change tack here slightly and carry on in the form of a DPIA. But don't worry, a DPIA can still function as your LIA from an accountability perspective. So then we move on and we ask, does the risk mitigation measures that we have envisaged reduce the risk to an acceptable level? So if the answer to this question is no, and you're in the DPIA zone, you will need to conduct a prior consultation with the Data Protection Authority, or alternatively, you might consider abandoning the project at this point, or going back again to see what you can do, if anything, to reduce the inherent risk. So here are some final thoughts. There is no prescribed method for carrying out an LIA in the law, or in any in the guidances, but there are a lot of them. A key step is the documenting of your reasoning behind the decisions made. And if your reasoning is sound, the documented LIA will demonstrate that you used an appropriate decision-making process to justify the processing, and that the interests, rights, and freedoms of the data subjects were appropriately considered. Guidance on the subject recommends documenting your decision-making rationale, including the DPC in their legal basis guidance, And much like a DPIA, an LIA is a live document and should also be reviewed if there's a significant change in the nature or context of the processing activity it relates to. So that's it for me. And now I'm going to hand it over to you for questions. And there are none in the Q&A at the moment, but we'll give it a minute or two, and I'm happy to wait. Okay, so Paulette, I see you've raised your hand. Would you mind popping your question into the Q&A if you can? Actually, what I'll do is Paulette, I'm going to give you your mic and you can ask your question live.
Thank you. Sorry, yes, I should have typed the question.
It's okay. How are you? It's nice to talk to somebody on the other end.
Yes, thank you. I can't figure out how to put my camera on, so sorry about that.
Not to worry.
But you can hear me, can you?
I can.
Yeah, I just wanted to double check with you. In general, I like to avoid Article 61F like the plague.
Right.
As I'm in the civil service, and it is my
Okay.
understanding that the Data Protection Commission has a very high bar for legitimate interest. I mean, I know they're all supposed to be equal, 61A, B, C, all the way through to F, but I'm just not sure. I'm just not sure about the validity of going to that. It should, the way I would look at it is, I would advise people to look at 61A, B, C, D, and E before they come to F.
Yeah, yeah. So you're right. In the a public body is precluded from using 61F
Yeah,
in the pursuit of their business
yeah.
activity. So, but for anything else, that isn't official business, then, 61F is open to you for that.
Yes, so really it's limited really in its own way.
Yeah, but you will have a legitimate basis based in law
Yes, for most.
for
Yeah,
most of
yeah.
for all of what you're doing. Anything that's precluded under 61F should be provided for elsewhere in the legislation that you're subject to.
Yes, it's I suppose the challenge sometimes is raising the awareness of that amongst everybody. And I'm the TPO, so obviously I know, but sometimes people want to go ahead with certain surveys, and
Yeah.
and then I get into this battle. But no, that's useful to know. Yeah,
Right.
thank you.
You're welcome.
Thanks a lot.
You're welcome. Thank you. Now I'm going to go to you next, John. I can see your hand up. I hope I'm not skipping people. Because I can see two questions in the Q&A, so I'll get to those in a moment. So I'm just asking John to unmute if he's still there. Okay, I'll go to the Q&A there. Thank you from David. And samples of CDD flowcharts. CDD flowcharts. Francis, if you're still there, would you mind just confirming which flowcharts that you want? Because I'm not familiar with the term CDD flowcharts. Okay, well, I think that's it. There's still over 50 of you there, so I'm happy to hold on if anybody has any other questions. And if not, in the next minute or two, I'm going to end the webinar. So thank you for your time. And I hope you got something from today. Thanks for coming in there. You're welcome. It was a pleasure. Okay. Bye, everybody, and we'll see you in the next one.